uh, what citizens decide to do by the exercise of their liberty. Once it doesn't cause any harm to any other person, once it doesn't cause harm to society, they should be allowed to do so. That is another argument. Another argument has to do with discrimination and equality, that nobody should be discriminated against on the basis of religion, ethnicity, sexual orientation, and what have you. One is a general principle, it should apply to LGBT folks as well. Then, of course, there is also the argument about Article 33.5, which you made reference to, since the compendium of rights we have in Chapter 5, are not exclusive. It is possible through Article 33.5 to import other rights into our fundamental human rights corpus, right? So those arguments have also, but as I said, these are matters that involve some balancing act, because it's not only about these rights, there are also other countervailing rights and duties, particularly in our context where our constitution also has things about culture, traditional values, and so on. So I agree with the view of the Constitutional Review Commission that perhaps this is a matter that should be left to the Supreme Court to decide. But let me also make this point. In many countries, the issue of LGBT was addressed by the legislature. It wasn't addressed by the courts. It's only in the US, for example, first starting with the Supreme Court of Massachusetts, that you had the court saying that, look, not allowing it is unconstitutional, not allowing marriage is unconstitutional, and later the US Supreme Court. But in many countries, to the legislature that amended the law to allow for LGBT rights. So the main question regarding LGBT rights, is this: it's a policy issue, right? And this being a policy issue, who should decide it? Should it be done by the legislature that can take into account many considerations, including perhaps coming out with alternative forms of family arrangement for LGBT people? So, for example, in some countries, they have partnerships different from marriage. Or is a policy issue that should be assigned to the Supreme Court? From a constitutional law perspective, these are the two main things. Who should decide? Should it be the legislature, or it should be the courts? So to think about, I leave this issue to you also to exercise your mind.
Okay, then thank you, Doc. Maybe we come to criminal law now, because time is fast spent, and then we also have to allow the students to come in. So with respect to criminal law, if you look at the past questions, I don't remember in terms of the written component, criminal law being examined in recent times. But generally, what advice will you give students as far as criminal law is concerned as they prepare to write on Friday?
Yeah, so criminal law, there are certain topics that students should always make sure that they are comfortable with before they take any exam that involves criminal law. All right, so the usual things first, what is crime, how crime is different from maybe civil matters, right? The functions of the criminal law in a modern society, the tests of a crime. How do you know that proceedings are criminal proceedings and they are not civil proceedings, right? Then, of course, we come to the principle of legality. Principle of legality is a very, very important principle in criminal law, and you have to bear that in mind. Then you come to the requirements of criminal liability, actus reus, and then mens rea, and then causation, and then defenses. So these are the general parts. But then when we come to specific offenses, there are certain offenses that students should make sure that they have studied them very, very well. You cannot master all the ingredients of the offenses in Act 29, too many. But at least there are major offenses that you should be familiar with. Of course, the first one is assault and battery. Assault and battery and false imprisonment, you need to know the essential ingredients of these offenses. When it comes to murder, manslaughter, know the ingredients of murder, know the ingredients of manslaughter, causing harm negligently, causing harm unlawfully, causing harm with the use of an offensive weapon. And when it comes to the property offenses, stealing, defrauding by false pretenses, and nowadays causing financial loss to the state, and then forgery. I would say that these are offenses that as much as possible, know their ingredients, have one or two cases that will help you to exemplify or illustrate these ingredients. And remember that the IRAC method of answering problem questions also applies to criminal law. It also applies to criminal law. So always, if the question is in relation to specific offenses, your very first sentence, first sentence, indicate what kind of offense is involved. Is it murder? Is it manslaughter? Is it conspiracy? Is it abetment? Is it preparation? Is it attempt? Just say that, oh, this question revolves around the crimes of conspiracy to murder, abetment of murder, and willfully causing financial loss to the state. The very first sentence, if the question is on specific offenses, to bring out the offenses that are an issue. Of course, before you set out the issue, before you go to the law, you discuss the law, then you apply the law to the facts, and then you draw your conclusion. So in a nutshell, in preparing for criminal law, don't forget the major offenses, don't forget your incurred offenses, and don't forget the format, the structure that is often used in answering problem questions in particular.
Okay, all right. Thank you, Dr. Bassett. So students, because we have just about 20 to 30 minutes to end the session, but we agreed on 2 hours. So we'll invite you, if you want to ask a question, just raise up your hand for me to call you first before you unmute yourself and then you speak, so they can have some kind of like ordered interaction. Thank you. And again, if a matter has been discussed already, don't ask a question about it so that we don't waste time. Yes, I think who signed this? Yeah, the person who signed this up. That is, please go ahead and then and speak. One person signed this up.
With the jurisdiction of the other courts in issues relating to all matters of course affecting chieftaincy. When we look at Section 57 of the Courts Act, it limits all the matters of causes affecting chieftaincy, apart from the Supreme Court, which takes appeals from the National House of Chiefs. But when we look at Article 23, a reading of Article 23 and Article 141 seems to say that the High Court has jurisdiction in issuing the prerogative rates to like quash decisions of the various judicial councils of the Houses of Chiefs or the traditional councils. I want to find out, does this in a way gives the High Court jurisdiction in chieftaincy issues or causes affecting chieftaincy? Thank you very much.
Okay. Dr. Bassett,
I'm going to take about three questions.
Yeah. Okay. Yeah. Let's take a 3 questions in a row. Yeah. So, Berimaba, yeah. Let's hear you. Berimaba,
my question.
Yeah.
Thank you very much, sir. My question, I think I've asked it, but if you have not heard, then I'm taking it again. The contention I'm having is that when we look at Section 57 of the Courts Act, it says that all the other courts, apart from the Supreme Court that takes appeals from the National House of Chiefs, are limited in their jurisdiction in all matters or causes affecting chieftaincy, either in the first instance or upon appeal. However, when we read a combined reading of Article 33 and Article 141, it seems to suggest that the High Court is able to issue prerogative writs in quashing the decisions of the various houses of chiefs when they do not follow, say, the rules of natural justice. So my contention is that does this provision suggest that the High Court has jurisdiction in matters or causes affecting chieftaincy? Thank you very much.
All right, okay. All right, then let's take Sally too. Thank you very much, but Sally.
Good evening, sir.
Yeah, good evening.
Sir, please, my question has to do with Article 22 read in conjunction with Article 130 and disparities between the jurisdictions of the High Court and the Supreme Court in certain matters. If you could come clearer for me, especially regards Article 130, when the Supreme Court can also have jurisdiction to speak on a human rights matter. I'll really appreciate that. Thank you.
Oh, okay. All right. Let's take the third question and then the three will be addressed together. I haven't seen any hand up, so it appears that we've addressed your questions. So in that case, Dr. Bassett, okay, I think one person, Sally, is your hand up again?
Yes, please.
What is it?
If Doc can quickly take again the justice, I would like case in relation to constitutionalism. My network was a bit bad during that time, so I couldn't really quite follow the trend of this discussion.
Yeah, we do that, but since this is recorded, because you are many, we cannot be repeating and the time is limited. So in case you miss something, you can play back the recording and listen, but we will deal with the questions anyway. Yes, so Dr. Bassett, let's go ahead with these two questions.
Yeah. So you know the first question about cause of matter affecting chieftaincy and then the prerogative raised. Yes, in the past there was a controversy, but this controversy has long been resolved. In the past, the controversy was that because the High Court had jurisdiction in all civil and criminal matters, and a chieftaincy cause of matter is a civil matter, the High Court also had jurisdiction, original jurisdiction in all chieftaincy matters. So there are a number of decisions, about two main cases, and you should look them up, where this controversy came to light. Now, but this controversy has now been resolved. The current position is that the High Court doesn't have jurisdiction, original jurisdiction in a matter or cause affecting chieftaincy. And the matter or cause affecting chieftaincy, you find it in the Chieftaincy Act, if it has to do with the installation, the disposition, royal properties. What is the cause of matter affecting chieftaincy is provided for in the Chieftaincy Act. The High Court doesn't have original jurisdiction in such matters. It has to do with the traditional councils, and depending on the level of the chieftaincy dispute, sometimes it has to be done at the regional House of Chiefs, the traditional councils or below. However, as you pointed out, the High Court has the authority to issue prerogative writs against institutions that deal with causes of matters affecting chieftaincy. So, for example, if the National House of Chiefs, or if the Regional House of Chiefs, or some of the traditional councils do not comply with the rules of natural justice, you can go to the High Court and seek a remedy. So those prerogative writs, in terms of prohibition, in terms of certiorari, are still available. In terms of matters affecting chieftaincy, and the High Court can issue such remedies or writs, but the High Court does not have original jurisdiction to entertain a chieftaincy cause or a chieftaincy matter. Now, the second question has to do with Article 2 and then Article 130. So Article 2 is on the enforcement of the Constitution. Article 130 is also on the enforcement of the Constitution, but there is this provision that says that in any proceedings before any court, other than the Supreme Court, if there are issues of enforcement there, those matters should be referred to the Supreme Court for its attention. Sorry. Now, there are two main cases that have explained the relationship between Article 2 and then Article 132 in particular. The first case is Ex parte Acosta, and every constitutional law student should be familiar with this case, Ex parte Acosta. So the Ex parte Acosta, Justice Enyin gave an indication, actually gave a test as to when a matter should be referred to the Supreme Court and when a constitutional matter could be handled by the High Court. So he indicated that if the matter is clear, it doesn't call for any interpretation, the High Court can deal with the matter. However, if it's a matter in which you have rival interpretations by the parties, then they have to refer the matter to the Supreme Court under its reference jurisdiction under Article 132. If it's a matter where you have a conflict in constitutional provisions, you have to refer. If it's a matter that affects the powers of certain constitutional bodies or organs, then you have to refer to the Supreme Court. And the same point was also made in Mekankan and the Republic, another famous case. And these principles have also been affirmed in recent cases. So when you take the Bafo-Boni criminal trial, the matter had to be referred to the Supreme Court regarding whether or not prosecution was bound to provide some documents, the kind of like discoveries to an accused person who is standing trial. Ex parte Acosta was applied in that case. So to answer your question directly, the Supreme Court in a number of cases has interpreted the legal effect of Articles 2 and Article 130. There is one recent case which appears to be a bit of an outlier or an anomaly in terms of the application of Article 132. You remember that in one of the Richard Crayson cases, the Court of Appeal had given a decision, and then there was a review application to the Supreme Court on the basis that there was a constitutional issue. So the Court of Appeal should refer that issue to the Supreme Court as required by Article 130. The Supreme Court basically said that before that matter came before the court, someone had also gone to the Supreme Court under its original jurisdiction on the same point. So by reason of that, the Supreme Court thought that the original action that had been filed would provide a better opportunity for the same legal issue to be addressed. So instead of the Supreme Court asking the Court of Appeal to stay proceedings and refer those constitutional matters to the Supreme Court for interpretation and for further direction, the Supreme Court basically denied any such reference on the basis that a similar issue had already been filed in the Supreme Court pursuant to its original jurisdiction. This does not appear to be in line with Article 132, which is cast in mandatory term, but that is the current position that the Supreme Court has taken in respect of Article 132 in terms of parallel proceedings. Ernest?
All right, thank you, Dr. Bassett. I noticed, Sally, okay, I think you've addressed your question. We don't have any more hands up, so I presume that there are no questions from our students. So since there are no hands up, students, any more questions before we draw down the curtain? Yeah, it means that our interaction has addressed questions that they had on. Okay, Saforo, let's hear you. Yeah.
Okay, thank you for the opportunity. Respectfully, I want a clarification on this question. What is law?
What is law? All right.
That is a
That's a
jurisprudential
jurisprudential question. Yeah.
That is the jurisprudential question. Hopefully, no such question will come close to you on Friday.
Hello,
Okay.
sir.
Okay. I think if we look at the
Excuse me, sir.
Yes.
yes, Sally.
Sir, sorry to disturb. If Doc could briefly walk us through some of the jurisdictions of the Supreme Court, we will really appreciate it, because we seem to know only the original jurisdiction into interpretation and maybe the appellate jurisdiction. But if you can talk us through other jurisdictions apart from the original and the appellate jurisdictions of the Supreme Court.
All right, let me do it briefly. Yeah, so the Supreme Court has a number of jurisdictions. As you said, the Supreme Court has original jurisdiction in certain matters. One of those matters is interpretation or enforcement. Now, the Supreme Court also has original jurisdiction in presidential election petitions. So if you are asked to discuss the original jurisdiction of the Supreme Court, it's not only its interpreting or enforcement jurisdiction, but it also includes its presidential petition jurisdiction, as well as issues relating to documents that affect national security, right? So if there's an issue about a document affecting national security, that matter has to go to the Supreme Court. So the original jurisdiction is about interpretation, it's about enforcement, it's about presidential election petitions, it's also about the production of documents that affect national security. Now, apart from the original jurisdiction, as you pointed out, we also have the appellate jurisdiction. And the appellate jurisdiction is essentially either criminal or civil. So cases from the High Court go to the Court of Appeal on appeal, and then from the Court of Appeal to the Supreme Court. In criminal matters, from the High Court to the Court of Appeal, from the Court of Appeal to the Supreme Court. And the only difference is when it comes to issues of treason, maybe from the High Court by 3 judges, then the matter goes straight to the Supreme Court. So we have, and of course, we can also talk about the appellate jurisdiction of the Supreme Court in matters relating to chieftaincy. So right from the National House of Chiefs, there could be appeal to the Supreme Court, usually subject to you seeking leave. So apart from original and appellate, we also have the supervisory jurisdiction of the Supreme Court. This is a jurisdiction that the Supreme Court uses to ensure that the High Court and the Court of Appeal in particular act within their jurisdiction, they don't exceed their jurisdiction. So where, for example, the issues of constitutional interpretation or enforcement, then the High Court still insists that it wants to go on with the matter. A person could go to the Supreme Court and its supervisory jurisdiction for the Supreme Court to look into the matter. Where also, for example, a judge has shown signs of being biased, somebody can invoke the supervisory jurisdiction of the Supreme Court to prohibit the judge from continuing to hear the matter, or sometimes to have certain orders of the judge quashed on the basis of lack of jurisdiction, and so on and so forth. Then we also have the review jurisdiction of the Supreme Court. This applies in situations where the Supreme Court has come out with a determination, whether on appeal or under its original jurisdiction, and the party is dissatisfied with the decision on the basis that certain fundamental errors have been made, or that there was evidence that wasn't available at the time that the Supreme Court gave the first judgment or decision. The person could apply for a review, but there are quite stringent conditions for applying for review. A review is not another opportunity to appeal the decision. It operates within very defined boundaries. So to answer your question directly, there are essentially, let's say, four main types of jurisdictions exercised by the Supreme Court: the original jurisdiction, the appellate jurisdiction, the supervisory jurisdiction, then the review jurisdiction. Sometimes we mention the reference jurisdiction, but the reference jurisdiction is actually an aspect of the original jurisdiction of the Supreme Court. The reference jurisdiction has to do with where a matter involving interpretation of the Constitution or the production of documents that affect national security coming up in a court below the Supreme Court by Article 132. Such matters have to be referred to the Supreme Court. Sometimes you call that the reference jurisdiction, but actually the reference jurisdiction partakes of an aspect of the original jurisdiction of the Supreme Court. I hope I have covered the various jurisdictions.
Yes, you have. Yeah, especially the one you made the point that the reference jurisdiction extends to original jurisdiction. If a matter is pending before a trial court and there's a constitutional interpretation, it can stay the proceedings and state a question for the Supreme Court to answer with respect to the constitutional dimension before it will continue with the determination of the case, having known the constitutional interpretation by the Supreme Court. So thank you, Dr. Bassett, for that exposition. I think there's one hand, I will soon be finishing, but there's one hand. Campbell, yes.
Okay, good evening, Doc. Thank you for the opportunity. My question has to do with Article 33(2), which states that the High Court is the only court mandated to issue these prerogative rates, that is habeas corpus, certiorari, and the rest. I'm getting confused. I want to know if the Supreme Court is actually estopped from also issuing such rates for others, because I can't seem to find anywhere in the Constitution which says that perhaps the Supreme Court might also issue such orders when perhaps such an order from the High Court does not sit well with any party. So I want clarification on that. Thank you.
Yeah, yes, there are provisions. Yes, so you're right.
The 132.
Yeah. Yes, there are provisions that deal with the power of the Supreme Court to issue the prerogative. In fact, remember that I think it's 132. 132.
Yeah, 132.
In addition to that, anytime that the Supreme Court is dealing with a matter, it has all the powers that any court in Ghana can exercise. So if the High Court can issue certiorari, the Supreme Court can do so. Because the thing is, apart from, let me get
and in fact, Dr. Bassett, yes, if you want to come to the Supreme Court, there's even go, the prerogative rates, traditionally, habeas corpus, prohibition, mandamus, certiorari, quo warranto. Okay. But if you come to the Supreme Court supervisory, we look at the ambit of Article 132. It can even go beyond these traditional ones. And that is why the provision says that, and may, in the exercise of that supervisory, issue orders and directions for the purpose of enforcing. So orders and directions. So they are not limited to only the prerogative rates. The Supreme Court has a very broad power, so long as is exercising its supervisory jurisdiction. Any order or direction which is appropriate for it to secure enforcement of its supervisory powers, the Supreme Court is so mandated by the letter and spirit of Article 132 of the Constitution, so to do.
132, okay.
That's absolutely right. So you see that 132 is very, very broad. I mean, the words, the expression use issue orders and directions. So very, 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 very good. Again, you may look at Article 1264. In the exercise of judicial power conferred on the judiciary, so the same expressions that issue such orders and directions. So very, very good. But generally, when the Supreme Court is dealing with the matter, it has all the powers. In addition to its own powers, it has all the powers that any court in Ghana may exercise.
Yes. Yeah, I think we have Grace Ampao. Grace Ampao would like to ask a question. Yes, Grace?
Yes. Hi, thank you very much. Good evening, sir. I came in a bit late, but I just don't know if it has been treated or not. I wanted to ask if I could have at least 2 or 3 constitutional modifications to it, like that provisions that can be amended. If Doctor can just take us through at least 2, I don't know if it has already been treated. I'll be very grateful. Yeah, thank you.
Oh, I think that, Grace, this is a well-discussed topic. And some of our previous recordings, I can go to the YouTube, we've discussed this extensively. But because you've raised it, I think Dr. Bassett, maybe if a word or 2 on it.
Let me make sure I understand the question. Is it about?
She wants to, I know previously, I'm sure she's coming from that angle. I told them that assuming their examiners are interested in asking questions relating to amendment of the Constitution, it would be a good idea if they can get at least 5 possible candidates for amendment in mind, so that assuming there's a question like that, at least they have 5 that they can accommodate. And I think that's what she's asking too.
Okay, so let me not answer this question, but refer them to a source.
Yes.
Let's refer them to the report of the Constitutional Review.
Absolutely, yes.
Yeah, it has a list of all the areas that Ghanaians say require amendment. So if you could just spend a bit of time to just read maybe the executive summary of the Constitutional Review Commission report, that would also be very, very helpful in terms of the preparation for constitutional law. So all of you should do that. Yes. Do you have a soft copy of?
Yes, I think it's online. I've also shared it on various platforms. It's also online, yeah. You just Google the Constitutional Review Commission report, Ghana. It's online, the full report with the executive summary and also the white paper by the then government, yes. Yes, I think, Grace, we've addressed your question. Okay, so on that note, on behalf of all the students that were able to come, and on my own behalf, Dr. Abdul Bassett would like to thank you for the time. As you rightly indicated, this is not the first time. Last year too, you were here to help with the last minute revision. And may God bless you for your time and love for students. So just before you go, if there are 1 or 2 sentences you would like to leave with the students.
Thank you so much, Ernest. Thank you so much for this opportunity. It's always a pleasure to interact with students. For teachers, that's our job, right? Interacting with students. But let me give you some words of advice. I wish you all the best on Friday. I know you do your best, and your best is more than enough to get you into law school. Please pay particular attention to the questions. Read the questions very carefully. Then the same pieces of advice that lecturers always give. You know, read the question carefully, write legibly. Please use simple sentences. We have graded scripts that we couldn't make the head or tail out of. Because the person is using English that we really can't understand. So please write legibly, use simple sentences. And it's always good to plan your answer. It's always good to plan your answer. Some students will use the first page of their answer booklet to plan. You see them planning. So introduction, cases, before they start writing out the answer in full. If you can do that, it's very, very helpful. The advantage of that is if you're not able to fully write out your answer, but I see the structure, I see the plan, and I get a sense that you have a sense of what the question is about. you are likely to get at least a pass mark, a pass mark, or even a high mark. So please read the questions carefully, know the requirements of the question, write legibly, plan your work before you start. And I believe you do your best, and your best will be more than enough to get you admission that you most require. So I wish you guys all the best.
Right. Thank you, Dr. Bassett. Yeah, so students, tomorrow, 4:30, I have I think about 5 or 6 panel. We'll not talk like what we did. We'll just be there to listen to your last minute questions and challenges. And I will deal with them for 2 hours. So from 4:30 to 6:30 tomorrow, you'll meet. So thank you very much, Doc. And all of you have a good night.
Thank you, Ernest.